welcome back to another Cordell and Cordell Town Hall this month. I'm Scott Trout, CEO and Managing Partner of Cordell and Cordell. And today's no different. We're here to answer your questions live, and we have some questions already that we'll be covering in today's 30 minutes or so that we have together. And keep in mind, as always, this can't be legal advice. Don't look for legal advice. Obviously, the best setting for that is in a consultation with an attorney who practices exclusively in family law like we do here at Cordell and Cordell. If you want to do that, you can go ahead and go online to cordell.com. You can schedule, get more information, schedule right there from the website. Don't even have to pick up the phone. Just type in an address or a zip code. It'll give you the office closest to you. And then we'll get that done either via phone, in person, or just like this via the web, FaceTime, Zoom, whatever it may be that's more convenient to you. Again, the consultation is the best place for that. If you have questions, you can submit those in the Q&A section today, and we'll get to those. Otherwise, if you don't have an opportunity to do that today, you can submit your questions to townhalls@cordelllaw.com, CORDELLLAW.com, townhalls@cordelllaw.com, and we'll get to those questions next month at our next town hall. We'd hope to see you then as well. So if you have any questions, obviously, again, Q&A section, we'll get to that. Let me introduce our panel of Cordell and Cordell attorneys that are joining us today. First, just outside of Minneapolis in Edina, Kelsey, welcome to the program.
Thanks, Scott. It's great to be here. As you said, I'm Kelsey. I'm out of the firm's Edina office, and I've been with the firm for about 6 years.
All right. Thanks, Kelsey. And then wrapping it up down in Florida, Enrico over in Jacksonville, staying dry, hopefully, for the time being.
Hey, Scott, and hello, Kelsey. Enrico Zanella here. I'm out of the Jacksonville, Florida office. Been with Cordell for nearly 5-6 years, and I've been practicing exclusively in family law since my graduation from law school.
Great. So again, submit your questions in the Q&A section. We're going to talk a little bit about spousal support, maintenance, or alimony just at the top here, just to kind of inform you of some changes that are going on. And we'll get to that here in a second. But again, submit them in the Q&A section. And if you need any more information, you can go to cordell.com or check out our social media and also our podcast. You can check out our YouTube channel. You can subscribe to our podcast that I do every week at Apple iTunes as well. So we'll be right back after this real quick break. All right, welcome back. So let's get to it. Enrico, we were just talking, and then Kelsey, we were talking off camera a bit about a number of the changes that states around the country we're seeing. In fact, I'm seeing more changes than I've ever seen, suddenly on a number of family law related issues that impact guys. Either they're about ready to go through divorce, they're in the middle of divorce, or they're now thinking about, do I need to modify? And we were talking off camera about maintenance or spousal support, alimony, and there's been some significant changes in the state of Florida. Enrico, why don't you talk a little bit about that? And obviously it'll spur some information that people may want to check out with their own attorneys in the state near them. Obviously not everyone here today is from Florida, but very interesting. I think this is the movement that we're going to be seeing, the next movement when it comes to radical, significant changes in family law.
Yes, and thank you, Scott. I think it is exciting to see all the changes to the law. In particular, in Florida, there's been a couple of pretty dramatic changes that are certainly going to impact any type of divorce claim moving forward. And the first one, that is the exciting one, is that there's no more permanent alimony within the state of Florida. Starting July 1st, there's been massive changes, and it really applies to any cases currently pending and any cases moving forward. Specifically, permanent alimony is now erased. So most guys in a long-term marriage no longer have to fear that permanent alimony is going to be something that's on the table. The court has also kind of created guidelines to see how long and for how much a husband, a spouse, is going to pay in terms of spousal support. Now, the court in Florida categorizes marriages 3 different ways. There's a short-term marriage under 10 years. There's a moderate term marriage, 10 to 20 years, and a long-term marriage, 20 years or more. In short-term marriages, if the length of the marriage is less than 3 years, there's no alimony. Now, in a short-term marriage as well, the max that the court can do in terms of length is going to be 50% of your marriage. For a durational, the court's looking at around 60% of your marriage. And then a long-term, over 20 years, you're looking at around 75% of the marriage. Now, that's important because that's the cap. That's the highest. And it's not necessarily the starting point. And then the court is going to decide what the spouse requesting for the support has a need for. And it's either going to be the lower of the need or 35% the net differences between the two incomes. So that's a very exciting change because this was something that was often litigated pretty hard, especially with permanent on the table. And I think it's going to be a benefit moving forward.
Yeah, it has to be, and I'm curious because Kelsey, we were talking offline as well. It may be similar to Missouri where I'm licensed in Illinois and Georgia, but primarily I practice in Missouri. There are no guidelines. There are factors, but every judge makes different determinations as to the amount of maintenance. And in Missouri, practically speaking, it is a lifetime award, very, very difficult to get it terminated. There are certain much easier grounds to modify, but there's just no structure like that. I was giving the example offline about a client who'd been married for 7 years, but been paying for 14. It just seems so unreasonable and unconscionable. So what does Minnesota follow? Very similar to Missouri?
So, as you're summarizing, there can be kind of a lack of predictability in terms of the spousal maintenance awards that we see in the state of Minnesota. And the reason for that is we have within our statute a host of factors that the court is going to consider, but it's very situational in terms of the orders that we're seeing coming out, right? So as we were, discussing off camera, sometimes you can, give the same set of circumstances to 5 different judges and they'll give you 5 different results because in the state of Minnesota, we have a child support calculator that tells us exactly what child support is to be if you're going to input, the specific factors that are required. But we don't have a similar calculator for spousal maintenance or concrete factors like Enrico was summarizing in the state of Minnesota that would give more of a degree of predictability on the maintenance issue.
It is. It's a pain point, I think, in family law, where especially in states like Minnesota, Missouri, you really can't do much in terms of guidance. I mean, we generally know. It's interesting that Florida uses that 35% rule. That's a lot of judges in the county, primarily, which we practice here, use that 35%. It's not law. It hasn't been overturned or reversed on appeal, but they go between 35 and 50%. They kind of look at that range of net available income. Just having some guidance like child support, like you said, it's easy for us to plug in numbers into a calculator and say, okay, here's where I think your maximum number will be. Then we can work backwards based on overnights, needs of the child, whatever it may be. And that just gives guidance to the client. So anyway, I just thought it was interesting to talk about as we were kind of starting the show off. And I would suggest to those, watching is check with your attorney who practices exclusively in family law so they're updated. Missouri just went through a very significant change in custody standard where the courts now are required to start at 50-50 time, which is huge. We've been pushing that. This is my 31st year of practice and been pushing that for all those years. And we haven't seen much movement in that until now. So I start to see around the country issues related to support, both child and spousal. So check with it. You may be ripe for a modification. It may be something that we encourage you to do, but obviously just get more information. That's the whole point. So continue to submit your questions in the Q&A section. I know we already have some, and we have about 15 minutes or so left. So let's get to the questions and we'll start going through that here. So Kelsey, I'm going to go ahead and throw this to you first from Dave. It says, my son, age 20, is going to Italy for 1 year to college. New York State is child support until age 21. He will be 21 by the time he returns. Dave says Italy is a reciprocal to U.S. child support laws, but Dave just wants to know, am I responsible to continue to pay while his son is out of the country at college in another country? And before you get to that, Kelsey, let me just throw my 2 cents worth. And the point, I just am going through a very similar issue, albeit I think we can remove out of the country from the set of facts, at least from my standpoint in Missouri. I have a client whose child is going out of state. And the question he asked me was, do I keep paying for child support, although my daughter is out of state, because I'm also paying for her room tuition and board and for college. And in Missouri, it does provide avenues for you to reduce or limit the amount you pay during those 8 to 9 months that the child's out of the state, so long as they're enrolled full time, they're still eligible till 21. And so Missouri does provide some of those avenues. But what do you say, Kelsey, specifically in Minnesota? Obviously, we don't have one of our New York lawyers online, but what does Minnesota do?
Right. So in the state of Minnesota, child support would continue until the minor child emancipates. And that is, typically age 18 or graduation from high school. And there are, a host of other factors that could apply to that analysis and, very situation dependent. But generally, if a child, for example, goes out of state, that obligation is going to continue until the obligation itself terminates because the child emancipates, or, for example, there's a motion filed with the court seeking to terminate the maintenance obligation for that specific child. Right. We see that happening where there are multiple minor children that a parent is paying support for.
Enrico, is Florida 18 or 21, 22? What is the child support age?
Thanks, Scott. Florida is the same as 18, and it really is very similar to Kelsey's jurisdiction in that there is a host of other factors. If it's otherwise emancipated, still in high school, but a reasonable graduation date of 19, military service. But 18 is really the date, or graduation from high school is the date that you're looking for there. And oftentimes, it has to be filed for a modification prior to 18. After the child is emancipated, they can't go and file for a continuation. Now, Florida does have some special exceptions to children with special needs. But again, that has to be filed before that child turns 18. And then the calculation for that differs because it's mainly looking at the child's need and requirement as opposed to the income of the parties.
Yeah. So, Dave, I think, given that Missouri, with our group here, seems to be the most like your state, there has to be avenues. It would be duplicative to be paying for a room and board and child support to maintain a home when the child's not there. So I would urge you to touch base with one of our New York lawyers. Asa Neff is up in New York. You may want to just go to the website, just get a quick consultation. Get your decree. Let's take a peek at it. Let's see what avenues are available to you to do and take action. It may be just a decreased amount, and that's still a win rather than, eliminating completely, because oftentimes we see a judge will say, okay, during the months in which the child is away at school until the age of emancipation, 21, 22, whatever your state provides, we're going to reduce it down to $100 or something, because the custodial parent has to still maintain the household, albeit they won't have those duplicative expenses that are still there. So I would encourage you to check. Let's see. Enrico William says, my ex keeps putting pictures of my kids all over social media, with which I don't agree for security reasons. She thinks I'm being paranoid. Is there anything I can do about this, about putting my kids' pictures all over social media?
Yeah, and we see this much more common now with the rise of social media and just everybody being so interconnected. Now, the court's jurisdiction is generally going to be over the child or children or over the parties. How much the court can do to third parties can be a little bit difficult, but the court really is there for the best interest of the children. So if this is a safety concern, a protection concern, the court's jurisdiction over those children are very great, right? And I highly recommend, if there is major concerns regarding where you're residing, pictures of the child, and the court can look into those things to determine, is it in the best interest of this family, child or children, to stop these kinds of things?
It's one of those where, first and foremost, I always start talking about documenting all of your concerns, objections. And if you get to the point where it's just become intolerable, now you've got a nice record of her not cooperating, discussing, realizing. It sounds like COVID. During COVID, we had parents not wanting children to travel during COVID, and one was objecting or being certain areas, and courts were willing to deal with those issues, even though, albeit that was health related. This is more, it could be security related. So certainly I would go ahead and make sure you make a record and then sit down with an attorney and see what you can do. All right, Kelsey, anonymous attendee. Here's a long one, but I think we can break it down. Unmarried, two kids under 10 going through custody issues in California. Mom is from Russia, wants to travel with the kids to Eastern Europe so they can hang with her dad, who is also a Russian citizen but cannot travel to the United States. They've been trying to do mediation to lock up an agreement and file it with the courts, but she's avoiding and dragging feet. Our temporary custody arrangement, which does not sound like it's court ordered, it just says notarized document between us, says no international travel unless interim agreement. He's made 3 agreements with her that involve me going with them, and she's backed out of all 3, and she's now pressuring him to take them solo without him. He doesn't feel comfortable. What are the options? And so I think I'd start with the assumption that it doesn't appear there's a court action, that they're just trying to do some sort of interim agreement.
Well, so we often see these kinds of issues in the family law realm, right? Where there are concerns about a parent taking a child out of state or out of country, perhaps concerns that a parent is going to take a child out of the country, for example, and not return them. And those can be really serious concerns. And, sometimes in circumstances where we think a parent is going to do that imminently, we start a custody action right away and get it filed, and perhaps even seek an order from the court precluding that parent from taking the child out of the country. That's in more, I would say, extreme situations, right? We also see situations where children have family members that reside in other countries, and parties don't have concerns about a parent absconding with a child. And so they reach agreements regarding travel, right? How passports are going to be obtained, the number of days or weeks that a child can travel with a parent. And the parties reach mutual agreements about that so that everyone is on the same page and has mutual expectations in terms of the child's travel and when the child's going to return.
Yeah. I think, notifying the Department of State and just starting there as well, saying that mom does not have permission to travel internationally is a good start. Certainly, I know that you have a notarized document between the two of you here in Missouri, and I'm sure in many states, if not California. It's not binding on the court. It's not enforceable until the court approves it, because they're looking to make sure that's in the best interest. So court action it just has to be done. And to get a temporary motion on file, you can certainly talk to any one of our attorneys in California through, San Diego, Sacramento, Walnut Creek, San Francisco. We have offices all throughout California. So I think it's worthy of taking action because it just gets so super complicated if, in fact, she chooses not to return or returns without the children. All right, Enrico, Jack has a question about beyond filing any motions or any additional motions. What do you do when your ex and her attorney are continually interfering and in contempt of court orders in a custody case?
Well, Scott, I think for this situation, it is the same as you stated earlier. You need to document everything. Anytime that there's been a violation of a contempt order, there's a violation of anything in a decree, you have to get it in writing, use text, use emails, and document everything. Absent court remedy, there's very little for you to do besides seeking counsel and litigating this maybe a little bit more aggressively to let the court know and let her and her attorney know that this can't be tolerated anymore. And the court's contempt actions are oftentimes pretty vast, pretty great, and they could do a lot to ensure that this doesn't happen again and again. And some states and some jurisdictions, especially in Florida, if there is a continual violation of a court order, the court, if it's been consistent, might even consider modifying it because they're not following the order.
Yeah.
So I would say, certainly continue to document it, put things in writing, email, things that could be used by your attorney for evidence purposes. And in this situation, I definitely think counsel and a consultation is extremely important, or else it's just going to continue.
Yeah. And there may be some remedies available to you in your state. For example, in Missouri, there's a remedy that is an expedited remedy called a family access motion. And it's specifically designed for interference or denial of custody, whatever it may be. And it gives the court the ability within, say, 45 to 60 days max to bring you into court, bring all parties in and have a hearing. And then they can issue sanctions. They can issue any type of remedy that you're requesting. Check and see if that remedy is available to you. In addition, there's some much more expedient, what we call indirect contempt, that a special prosecutor can bring, for example, here in Missouri, to enforce custody or to stop interference, because typical motions for contempt orders to show cause can take, and especially post-COVID, can drag on 6 + 8 months. And it's obviously it's not the time that you have, but I would first and foremost check to see if there's some much more expedient remedies like the family access motion here in Missouri before you do anything else. All right, Kelsey, let's talk. Dave lives in Colorado. Dave's ex ordered a parental responsibility evaluator and a report in 2018. The report was dismissed as Dave was able to prove bias. Last week, she's asking for another $4,000 report referencing the exact same things that were raised in the 2018 report. No new information. How does Dave go about asking the court to dismiss this?
Well, I think the question here is what's changed, right? Since the last time that these issues were looked at. And it sounds like, per what Dave has summarized, nothing's different. And so the question then is there a need to look at these issues again, right? Is there a need to pay $4,000 to walk the same road that we already have? And it sounds like under these circumstances, a court might say, no, there isn't, right? And if the spouse is seeking or ex is seeking to litigate those issues needlessly, perhaps it becomes a basis to request attorney's fees.
Mm-hmm. Yeah, there's a legal standard in Latin terms called res judicata. The thing has been decided. And obviously, Dave, if you have an actual court order where the court entertained those facts and they're the same, nothing new, and they issued a dismissal, you want to look and see if it was dismissed with prejudice or without prejudice, or if it was voluntary, because if the court made a ruling, you want to go speak with a lawyer. One of our offices in Colorado can help you. And see if that issue's res judicata, as Kelsey, talks about something new. If there's nothing new, that thing's been decided. That is a basic term in law, res judicata. So I would check with that. All right, Enrico, Tom says he has a 401k that his wife is not aware of. There's not much, but enough to pay down debt and go towards lawyer's fees or his lawyer fees. If I were to pull that money before divorce proceedings occur, how is that viewed? And what trouble could that cause for Tom?
Well, first off, generally in a divorce proceeding, there's going to be a standing order that takes place upon that divorce being filed that kind of stops the parties from dissipating any funds, pulling any funds, withdrawing any funds. When you're dealing with a 401k and it's prior to the divorce, the major concern you should also be looking at is the tax implication. And we always advise before you even touch anything from a 401k, a retirement account, to speak to somebody that's certified, an accountant, somebody that's certified in tax, to be able to guide you on what implications are going to be if you withdraw that money. Oftentimes, the court can go back a year, go back 2 years, and look to see whether or not you've pulled money from these funds and where have they gone. My concern is that with a 401k, if you pull it out prior to the filing, there's going to be a tax implication. And are you going to be then solely responsible for that tax implication moving forward? And now you're splitting these funds much less. In the divorce proceeding, when it looks at retirement accounts or a 401k, most states, most jurisdictions are going to allow for there to be some type of qualified domestic relations order that can split those funds without that tax implication. But oftentimes, when a divorce is pending, you might have the ability to pull out those funds for attorney's fees. You just have to be smart about it and make sure that the finances are correct, that you're not hitting any tax implications. And obviously, if your wife is not aware of those funds, she's going to be aware of them during the divorce proceeding. You have to do a full and frank disclosure. And failure to do that, you could lose credibility, or even worse, cost you more in litigation for the amount that you actually pulled.
Yeah. You do. It's that economic waste that you have to be very careful about before divorce. Obviously, as you mentioned, Rico, once the divorce has started, there usually are some standing orders. I always have a bit of caution when someone says, I have a asset that my wife is not aware of. Ultimately, you're going to have to disclose it. You don't want it to look like you are trying to hide money. If you're trying to pay down marital debt, obviously, okay. That's probably something that I would, after looking at all the facts, may tend to tell a client that's okay. But there's so many factors that require a consultation to kind of review the whole and make sure you're making the right decision here. All right, just a few more minutes left. Let's see. Kelsey, let's talk about Darren. Darren is living in Georgia in the middle of a divorce. It's very ugly. He's offered to split everything 50-50 numerous times, and she won't come to an agreement. The questions regarding the house. When they got married, she had lived in her house for 3 years. She had a 30-year note, made very little progress towards principal. We were married in the house for 5 years, had 2 kids, and relied on both our incomes to make the payment. We sold it a year after the pandemic. We rolled all of that money into a joint account, then bought another house with both our names on the property, and have lived there for 2.5 years. The judge made me move out. We have a lot of equity in the house. I've been told that usually there's an equitable distribution of assets. I've also heard of many fathers getting nothing for the house. Each situation is different. What is realistic expectation with regards to what I can get out of this house?
Well, Darren, first, I'm sorry to hear that your divorce has gotten ugly. I think that in terms of the question, we're looking at both marital and perhaps a non-marital interest in the property for wife. In the state of Minnesota, non-marital property is anything that a party has inherited, had before the marriage, or was gifted, right? So I think what Darren's summarizing is that his wife may have a possible non-marital interest in that property. But the good thing to know is that at least in the state of Minnesota, it's her burden to trace it, right? And so if she's able to do that, she may be able to make that claim as part of the proceeding. Otherwise, the question surrounds what is the marital equity in that property, right? And there's different ways to determine that. Of course, you're going to look at the mortgage statements to determine what the principal balance is on that property and the mortgage. But there's other metrics for looking at value of a property. Sometimes we do comparative market analysis by a realtor. That's not going to tell you what the house would appraise for. It would tell you what it sells for, right? And you could actually pay for an appraisal. That would tell you what the house would be valued at. Sometimes we use other metrics like Zillow or online resources to look at value of a property as well.
Yeah. And I think that, Missouri in particular, there's some items called source of funds, contribution. The courts may look to that. What's interesting here, at least in my experience in Missouri, is that time period and the actions of both parties in choosing to roll that money into a new marital a home because it was acquired during the marriage. So it's clearly not separate property. There may be some contribution or source of funds arguments to be made, but I would certainly have a conversation with one of our Georgia attorneys in our Atlanta metro area and make sure that what direction should be going in. It's a very difficult argument. I can tell you, I've been on one side where our client has been the major contributor towards a marital asset, and we've tried to argue source of funds to pull that out first. And it's a tough road to argue, and judges are reluctant to do it when a significant time period has gone by. Obviously, if it's a short-term marriage and it's reasonably identified where we can source the exact funds that have gone into it, they may buy into that argument. But either way, certainly if you're on the other end where you want to split this asset 50-50, you're in a much better position than it is to ask for a greater share, but certainly sit down with one of our attorneys. All right. Well, that is all the time we have today. We're already just a little bit over 12:30 hour Central Time. Join us next month where we're going to again do a virtual town hall, which we'll set aside some time. We'll have some guests and again, another panel of our Cordell and Cordell attorneys. We'll set aside some time to answer your questions, but you can visit us online at cordell.com. Check out our social media, as well as the Cordell YouTube channel, where all of our previous virtual town halls and podcasts are there. You're going to find a topic that is important to you as well. Submit any of your questions to townhalls@cordelllaw.com. and we'll get to those next time. So thanks for joining. Until next time, have a great week.